All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the word nonsense is what you're talking about originally.
Originally, Your Honor, but then in rebuttal, there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth. There's lots of law in this, Your Honor, and essentially these comments, the repeated comments, constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard.
All right, now let's take a listen to what exactly Eric Nelson was referencing. And we put together some of the statements that were being made by Jerry Blackwell, the prosecutor, during his rebuttal closing argument that the defense was objecting to and believes was the basis for prosecutorial misconduct and a mistrial. And my guess will be at the top of their list when it's time for an appeal. Let's watch.
You didn't get the whole story either. You got bits and pieces and parts. And I call them a story, ladies and gentlemen, because it's either completely not true or the facts have been altered in order to make a point to you, which also makes it a story. What you were just told, and that was attributed to Dr. Baker, is that somehow he meant that this was an unexpected result. It was an unexpected result of the law enforcement dual restraint and neck compression. Dr. Baker didn't come in to talk to any of us about use of force by police officers. He's not in the mind of any police officer. It is not what he said. They were simply words that were put into his mouth, but you check your notes on what his testimony actually was. But what you have gotten here is a number of what I'd call stories that once you analyze them and you should. So finally, ladies and gentlemen, I will sit down in a minute, but I wanted to save till the end what I thought was the biggest shading of the truth, or what I call story.
I object to that, Your Honor, and
You'll disregard the phrase shading the truth.
All right, let's bring in Court TV legal correspondent Julie Janae, who joins us from Minneapolis. Julie, this was a point, it's right at the end of the trial, where it seemed Eric Nelson was pretty upset. I mean, he doesn't get upset, but seemed pretty upset from what he's saying, that, hey, this is it. What's going on here, Your Honor? And it seemed like the judge was not too happy with it either, but did not declare a mistrial, obviously. But were there other points where this type of theme was going on during the trial or during closing arguments?
Well, you know, it's interesting watching it back how Eric Nelson was making that eye contact with the judge. You can see him turning his eyes, and it looked like he was pleading with the judge over his mask. And it gives me the assumption that I'm assuming that the agreement between these parties was that they wouldn't make a lot of verbal objections during closing arguments, which can be typical because you want to let that attorney, the flow of their closing argument continue. And it's not evidence anyway, so the jury is not supposed to take anything that these attorneys say that's not in evidence as evidence. But you could see Eric Nelson looking to the judge and realizing, okay, maybe nothing's going to happen, looking at him again every time the word story is mentioned. And then finally he verbalizes objection, Your Honor, and he sustained and overruled those in different instances. But you heard some of that during Stephen Slisher's initial closing argument, which came first. Then the defense was able to go, and then this was the very last thing that this jury was hearing from the attorneys in this case, that rebuttal remark from Jerry Blackwell.
Let's bring our special guest into this conversation because we have a few things to get through here tonight. Joining us tonight, Lisa Bloom, civil rights attorney, former Court TV anchor. She is with us, and criminal defense attorney and civil rights attorney Ron Kuby with us as well. All right.
Hey.
Ron, I'll start with you. Would you be jumping up and down? Was the prosecutor crossing the line? Is this something that could rear its head on an appeal? The belittling of the defense, the shading of the truth. The defense is making up stories.
As a general rule, you shouldn't do that. And I think everybody recognizes, and I'm sure prosecuting counsel would have come to the conclusion, knowing this was going to be an issue, that he should have used better words. But you almost never get a conviction reversed, especially in a case like this where there was so much overwhelming evidence based on a few isolated comments from a prosecutor. Almost invariably, an appeals court will say something like, well, it's better he shouldn't have said this, it was harmless error, or they'll note what the judge did after the first time, which is to say, objection, sustained, the jury will disregard, and move on. So I don't see much actually happening here. I really don't. This would not be what I'd be jumping up and down about.
All right. Eric Nelson said those two words, though, Lisa Bloom, prosecutorial misconduct. Well, I always get scared of that when I was a prosecutor. If I would hear those words, it would certainly wake me up. And the other, Jerry Blackwell, not a prosecutor. I mean, he's a civil attorney, Lisa.
Boy, I got to tell you, I have a different take on this. If I'm in trial and the worst thing somebody says about me in closing arguments is that I had a story, I was making up a story, I mean, that's probably a pretty good day. I get called all kinds of names and get accused of all kinds of things, and it's closing argument. I mean, and to say I give it right back that, they're coming up with false stories and false claims, but here's why, of course, and then I have to prove it, and then I put up the evidence to show why the other side's position is false. But I think this is really making a mountain out of a molehill.
All right, we'll see if that if that molehill grows any larger on appeal. Here's Eric Nelson now talking about another issue, and this is actually him during jury selection.
I am gravely concerned, and I know we've been dealing with these motions this morning, but I am gravely concerned with the news that broke on Friday relevant to the civil settlement in this case. This is, by my count, notwithstanding all of the high-ranking state officials that made comments at the onset of this entire situation, but by my count, this is the third highly prejudicial and incredibly prejudicial press leak or press release that has very suspicious timing, to say the least, and has an incredible propensity to taint a jury pool. Because what we've been hearing from the jurors who've come in so far is they may run into a headline record $27 million civil settlement. If they're and the court has granted permission for these people to be scrolling through Facebook, it's going to be unavoidable. And I think that there are certain things that the court should strongly consider. I think there are things that if the court denies those requests, there are things that the court should potentially be obligated to do to to protect the jury from future questionable press releases. If the court is not inclined to continue or change venue, and we can address these again further, I think there are things that the court must do, which include calling back the 7 jurors that are currently seated on this case and inquiring. I think there needs to be specific inquiry as to this settlement. It's amazing to me is, you know, they had a press conference on Friday where the mayor of Minneapolis is on stage with city council, and they're using very, what I would say, very well-designed terminology. The unanimous decision of the city council, for example. It just goes straight to the heart of the dangers of pretrial publicity in this case. I think the court should also strongly consider providing the defense with extra strikes. It's another potential remedy. And I think the court should strongly consider the immediate sequestration of jurors throughout the pendency of this case.
All right, you heard about change of venue, sequestration, and it's all about that civil settlement at this point for Eric Nelson. Here's the mayor at that press conference where they announced the $27 million.
Every American remembers where they were when they first saw it. When they first were forced to process the incomprehensible, recognizing our historic shortcomings and what we need to do to improve going forward. There are certain events like that in world history that seem to suspend time, where the world stopped. And those moments tend to stick with us. And our Black community has endured deep and compounding trauma over this last year, none perhaps more acutely than George Floyd's family standing with me right now.
Julie, Janae, give us an idea. You were there. How big was this story, this news of the settlement in Minneapolis?
This news was everywhere. It was pervasive. People were talking about it. It was on the newspapers, on the news, and the $27 million amount just really stuck with people, perhaps because they live here and know that that's something that's involved with their government, perhaps their tax money, but it was national news, so it wasn't just here in Minneapolis that this made headlines, but definitely locally, everyone was talking about that decision that was coming so close to the trial.
Lisa Bloom, do you think this is a real issue? I mean, this is going on during jury selection is when they decide to announce it.
Yeah, this one has more of an effect on me. I think this jury should have been sequestered. There was so much media attention going on throughout the entire case, as there should have been, but I think it would have been better if the jury was sequestered. I don't know, and probably your reporter does, the extent to which jurors were asked during jury selection about how much they read the news, how much they see the news. You know, I've tried high profile cases. You'd be shocked at how little some people follow the news. Some people are really unaware of everything that's going on. Things that seem very big to us, they just have no idea. Some people are just really not interested in the news. So I don't know if they were asked questions about this, but they should have been.
Yeah, they were asked questions, Ron, and a lot of them knew about the $27 million, but they were able to put it aside.
First of all, it's hard to know which way the $27 million was going to cut. I mean, from one perspective, you can say, oh my God, the city is admitting our police did some horrible thing and therefore we're tainted. Or you could just easily say, wait a second, $27 million got paid out. I think that's enough here. We don't have to necessarily be criminalizing a cop. They paid a civil judgment. But more important, Vinny, this is not the first huge case in American history. I mean, we can start with the Aaron Burr treason trial in 1807 through Sacco and Vanzetti, the World Trade Center bombing. That was kind of a big deal as well. We've learned how to deal with pretrial publicity in the context of jury selection. You question the jurors very carefully. You make credibility assessments as to whether they're being truthful as to whether or not they can put aside what they've read and heard, or whether they're just using this as an excuse to carry out an agenda. Sometimes you do give more peremptory challenges, or as Eric Nelson said, strikes to the defense as well as the prosecution in order to get rid of, questionable jurors. But we don't stop a case because there's a lot of publicity. If we were to do that, the criminal justice system would be entirely in the hands of the media.
All right. Defense attorney Eric Nelson also went on the record at the start of jury deliberations regarding government officials commenting on the trial publicly.
Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating a jury, demanding that if there's not a guilty verdict, that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned.
Congresswoman Maxine Waters was at a protest for the shooting of 20-year-old Dante Wright in Minneapolis that weekend when she made comments about Chauvin's trial. Here is some of what she said.
I am very hopeful, and I hope that we're going to get a verdict that is say guilty, guilty, guilty. And if we don't, we cannot go away.
All right, let's bring back in Julia Janae. Julia, at this point, the jury is not sequestered yet. They're only sequestered during deliberations, right? This is before deliberations. You have the shooting of Dante Wright. You've got the protests. You've got Maxine Waters talking. You've got President Joe Biden praying for the right verdict. All this has taken place.
This was just a couple of weeks after the death of Dante Wright, which was another point that Eric Nelson wanted to get this jury sequestered for. This was when the trial was still going on. He was concerned that the reaction in Brooklyn Center would in some way cause these jurors to fear and choose a certain verdict because of what they were seeing on the news. And they were instructed to avoid news about George Floyd's case, but not about Brooklyn Center. So likely even this comment by Congresswoman Waters would not have been something that they were not allowed to view because it did not have to do with the particular case that they were sitting on.
All right, we only have like 15 seconds each. Lisa Bloom, big deal or no deal?
Listen, Maxine Waters did not threaten violence. She just said there should be protests. And of course there should be protests. Confrontations. That's not the same thing as violence. So don't conflate them. Having said that, it would have been better if she waited for the verdict. It's better if public officials don't make statements. But I don't think this is enough for a reversal on appeal.
Ron, 15.
Jurors are presumed to follow the instructions they're given. And unless it can be shown post-trial that, in fact, the jurors deliberately violated their oaths and engaged in exposure to highly prejudicial factual information, this conviction is not getting overturned because Maxine Waters has a view of the proper way to protest racist violence in America.
All right. Julia Janae, thank you so much. Lisa and Ron are going to stay with us. When we come back, we're going to talk about the shooting of Ma'Khia Bryant in Columbus, Ohio. new video released, 911 call released. That's next.